Yes! Hello, my beautiful friends. What an amazing day it is. We're waiting for these tubes to connect themselves all across the fruited plain on this lovely and amazing day. Of course, we're excited to be here to celebrate the close of the week and the much awaited and very cherished Friday. We made it through another very busy week. And my goodness, my friends, what a Friday treat we have in store. Fresh out of the oven, like minutes ago, the Supreme Court dropped an opinion on a TRO injunction type case, and we're going to get into it. Now, we've got just a very short opinion from the court, and what's curious about this one is John Roberts would have denied the application. The full court granted the application, which means John Roberts was still being ornery. So Amy Coney Barrett, it sounds like, joined in with the Republicans, and we've got our very first stay granted from the Supreme Court, going back down to a lower level court in Massachusetts. So very good news coming out of the Supreme Court today. Now, what is this going to mean, and how will this trickle out to all of the other cases? Time will tell. But we got some Supreme Court business to attend to. It's so fresh, I couldn't even put it in the thumbnail or in the title, but we'll get to it. So we'll start there. Then we got some other business to attend to, talking about this dude who has been told he's coming back to America. And the judge who ordered him back to America is this judge, Judge Paula Zinnis, who is this woman. And she is bringing him back. She issued an order, and that order looked like this. And he's coming back. He's in El Salvador at that prison down there. And they say he's got to come home. Not that he can go to another facility, but put him on an airplane and fly him back and do it immediately. Now, we got some updates on what happened at the hearing because CNN was there. They were reporting on what went on when Trump's DOJ was arguing about this today. And we'll go through all of that and more. More discussion on the border because the Democrats went down there today. There's Benny Thompson. Oh, look at that outfit. Looking good, Benny. They're going down there to inspect, I guess, the internment of migrants or something that Trump is imposing upon everybody. So Benny Thompson's down there. I got some reaction here, a couple of clips from Wesley Hunt and some spokespeople. And then we'll talk about Judge McConnell, this judge right here. This is the judge that we've had a lot of conversations about because he said that Trump has to bring back that FEMA money and divulge it, divest it to all of the various states. So he came out with a new opinion on this today. We'll read through it and see what he said. Of course, a lot of the stuff is being appealed. Now, this is going to be the preliminary injunction portion of this, which means it will certainly become a lot more appealable. But this judge is also facing impeachment questions and claims based on his problematic history and conflicts. And so we'll go through those impeachment resolutions here soon, and then hear from Mike Johnson on what can be done with this budget and perhaps even addressing some of these very issues like FEMA funding, billions of dollars being grifted out, and more. Then we'll do a quick update on this appeal. Trump filed on appeal in this case, appealing another Biden judge, James Kelleher Bradar. This case got appealed there. They filed it in the Fourth Circuit, filed a motion for a stay pending appeal. So we'll hit the highlights on that and then discuss what that case means and what the administration is doing. So a bunch of good stuff today, my friends. Very glad that you're here and with us. And we're excited to get into it with you. Want to remind you that we do members only streams on Saturdays. So if you're looking for something to do tomorrow, 12 noon Eastern time, thanks for becoming a member. We're going to roll out those research files that I was just sharing with you tomorrow. So we'd love to have you come and join us. We'll explain it and it'll be a little fun conversation. So it's a great way to support our show. You can join on YouTube. You can join on Locals, watchingthewatchers.locals.com. We had a great members only stream this morning. We really tried to deliver for our members. We stream a bunch. We have a great community that we're developing and fostering. And that's what it's all about. Community. It's going to make you live longer. There's science that says that. So, all right, we got a bunch of good business to attend to today. So let's get to it, man. Because We got Supreme Court business fresh out of the oven, just making sure all of our feeds are percolating appropriately. And I do believe they are. Good. All right, so let's get to it. Starting right here. The Supreme Court of the United States has finally spoken. We've been waiting for something, even a little bit of a tidbit of a smorgasbord of something, and they gave it to us today. You can see this came down in a per curiam opinion. So it is the opinion of the court. There's not a single judge who's taking ownership of this decision. And it looks to be a very close decision, a 5-4 decision, because John Roberts would have denied the application for a stay. And so some background on this case before we get into it. Very short opinion from the Supreme Court. You can see it's just a couple pages here. It's coming up from the District of Massachusetts. And you're going to see the very first word here basically is on March 10th, the lower level judge did a thing. So what did that lower level judge do? Well, they issued this order. You can see March 10th is the date of this order that came out from the District of Massachusetts. And we'll read through what happened here just very briefly so we have some context for what the Supreme Court has done. But for background, this is a judge who is called Myong Jin Jun. And as Joe Biden did regularly, he appointed a ton of people who were not born in America. Now, that is an interesting pattern from Joe. It's curious to me how he can't find people from, Massachusetts who were born in Massachusetts who could come and interpret the American Constitution based on their American heritage and upbringing and living in the country. But Joe Biden did this for a lot of people. This guy was born in South Korea, in Seoul, and has now been appointed to be the judge of Massachusetts and is now ruling on constitutional issues that impact the entire country, acting like he's a natural born president, but he's not. So anyways, just a little side note there. But Joe Biden appointed this guy, and he was a Boston City judge before he then went and worked for the ACLU, bunch of other things, served in the National Guard, and was part of the American Bar Foundation. Joe Biden appointed him, and he was confirmed out of committee and so on and so forth. So now he's in charge of apparently the country, and he decided that accordingly in this order. He said, all right, on March 6th, a bunch of these blue states, this is this judge writing, California and Massachusetts and New York and Maryland and all of them, they sued the Secretary of Education, Linda McMahon. They said that on February 7th, the Department of Education terminated all grants that were awarded under the TQP program, the Teacher Quality Partnership Program, whatever that is. Grifting teachers are us. So plaintiff states filed a TRO. They said, you can't cut off those funds. How dare you? They held a hearing. This judge said, I grant their motion and I enter a TRO against Trump, give them back their money. So then Trump says, wait a minute. The waiver of sovereign immunity in the APA does not extend to contract claims, which is something we've talked a lot about here. So, right, it's hard to sue the government because they've got sovereign immunity. So they pass laws. They say, well, if you want to sue because there's a contract breach, we're going to set up a special court for you. It's called the Court of Federal Claims. They actually did that under the Tucker Act. Not that Tucker. And set that up. But you can also sue under the APA, but only if there's a waiver of sovereign immunity. And specifically, there isn't a waiver of sovereign immunity that would allow you to sue if it is a contract claim under the APA. There's a whole separate court for that. We've talked about this a ton here. These judges just don't understand it. They're going to get told here in a minute, though, from SCOTUS. Now, the states disagree, saying, no, waiver of sovereign immunity says we can sue you right here. We can sue you in Massachusetts under this judge from Korea. Now, very recently, another session in this district examined this precise issue in substantially a similar case to this one. Massachusetts, this is this judge writing, says in that case, in a thoughtful analysis, another judge said that the essence of the action was not actually a contract. Remember, they drape these things in constitutional claims, even though they're just contracts. Like, we just got our contract canceled by the government. But they say, oh, our free association rights were canceled under First Amendment. He says, I agree. And this judge is just going to copy and paste Judge Kelly. Because why, reanalyze it? Yeah, that sounds good. Here, they say they're seeking relief, equitable relief. They want the grants reinstated, okay? It's not because they're not suing because the contract was canceled. Hello. They're suing to just turn the contract back on. You know? Which is like to undo the cancellations. Oh my gosh. And the judge is like, yeah, it's equity. It's not contract. Plaintiffs, it's so ridiculous. Maybe that's how they do things there in South Korea. I don't know. But plaintiff states also, this blue state, seek to enjoin defendants from implementing, giving effect to, maintaining, or reinstating under a different name the termination of any awarded grant. So preserve the status quo. So I think you're going to win. I begin with the likelihood of success on the merits, which is considered the most important of the four elements. You're going to win this, right? This judge, he's just going to get told in a minute. I think you're going to win. He writes, the record reflects there was no individualized analysis of any of the programs, and that it appears that all the grants were simply terminated. You didn't look at them on a case-by-case basis. We've already gone through this routine with the USAID case. And then they said, yeah, we did. Marco Rubio was up late that one night for like 3 nights. He had like 5 Red Bulls. He was like, yeah, another one. Just keep it going. Yep, canceled. Another one. Canceled. I see no reason. This judge, I see no reasoned explanation articulated for why the department did what they did. Okay, this judge is now in charge of the executive branch. It's ridiculous. Well, you didn't explain it good enough for me to approve and sign off on your executive decision. First, the termination lists several theoretical bases for the termination grants. It says you're canceled because you do DEI, or you're not free from waste or fraud, or it could be this. He says, well, that's not clear enough. I need a reasoned explanation. You don't have power unless I sign off on it. There is no indication that the department examined the relevant records. To the contrary, it feels like they didn't look at these individually at all. And so since you didn't look at them individually, I find this is arbitrary and capricious under the APA and award them a victory. Says the department's, he's going to get told in a minute. For these reasons, I think they're going to win. Wrong. Under the APA, and I'm going to say that it's arbitrary and capricious. Sorry, Judge. So the blue states have adequately shown that they would be irreparably harmed also if we don't grant this TRO. He says, saying an irreparable injury is an injury that cannot be compensated for later. And these are two sides of the same coin. The termination of funding for California State, with the objective of training and developing high qualified community-centered teachers, has resulted in the loss in mentoring of 26 students, and the loss of stipends for 50 incoming students who need these stipends to participate in classroom teaching. Oh man, they're doomed. Now here in Massachusetts, where Boston Public Schools has relied on their money, right? He's like, well, we need this money. The abrupt termination of this grant has resulted in the loss of 3 full-time employees. Again, Judge, these are decisions that the president makes. These are political decisions. If the people are unhappy with these firings, Trump can be held accountable at the ballot box. What is happening is these judges are substituting the TRO rules, which are not for this, okay, not to come in and make political judgments and issue nationwide injunctions on the basis of political discretionary decisions. This judge is not politically accountable to anybody. That's why he can do whatever he wants. He might think this is an appropriate benefit because he knows those guys and they save him a parking spot at their happy hours. But it's apparent, he says, these harms have already resulted. And I agree with the states that these damages and further compensation later down the line are not going to make us whole. And so they have established irreparable harm. Again, SCOTUS is going to reverse this in a minute, but he wraps up saying, finally, upon consideration of these, the public interest supports these. If I don't grant this, the record shows if I deny this relief, dozens of programs upon which public schools and universities and students and faculty and teachers rely will be gutted. That's the point. Only the strong will survive. That's the point. On the other hand, if I were to grant the TRO, as another court has put it, defendants merely would have to disperse the funds. All they have to do is just give the money out. And I find that absent an order, there's a serious risk that these services are going to be disrupted, and it's integral to their daily lives. Like, these are all political considerations that we know. So for the reasons above, this judge wrote, Trump shall immediately restore the states to the pre-existing status quo. Give them all that government money back. Says Trump is also enjoined, prohibited from stopping the funding of them. You're also enjoined from stopping the funding of other entities. Within 24 hours of this order, you shall provide notice about these people getting their money back. You should confirm your compliance with this TRO. This TRO shall become effective immediately upon entry by this court, and more. By March 11th, the party shall give us a briefing, and so on. Obviously, Trump was not happy about this and appealed it. So, of course, this was signed off by the South Korean judge called Myong Jae Jun, who is now in charge of the executive branch, saying you can't cancel these funds, okay? You didn't do it to my satisfaction. Now, all of this is obviously wrong. So Trump appealed it. It went up to the Court of Appeals, and then it went up to the United States Supreme Court. And now that we're caught up, here we are. Trump applies to the Supreme Court wanting to vacate Judge Young's order issued out of Massachusetts. So the Supreme Court has come back down, what I believe is a 5-4 decision. We can look at it in more detail with John Roberts joining the libs. Came out and said, all right, listen. On March 10th, the United States District Court for Massachusetts issued what it styled as a TRO, okay? They call it a temporary restraining order. And we've here talked a lot about these. We know what they are, okay? They're preliminary injunctions. They call them TROs because they call everything things that are not what they are. Okay, we can see that it's a preliminary injunction on our face. Even a 3-year-old could see that. That's an injunction. Well, it thinks it's a TRO. It's not. It's not. It's an injunction. Everyone knows. Okay, even no matter what you put on it, how much wigs or dresses or whatever, it's an injunction. Enjoining the government from terminating various education-related grants. Now, the order also requires the government from Judge Young to pay out past due grant obligations and to continue paying obligations as they accrue. So everything Trump said with the Department of Ed is reversed. Now, the district court's conclusion, writes the Supreme Court, rested on a finding that the states are likely to succeed on the merits of their claims because they were suing under the APA. And remember, tons of lawsuits that we've covered here are also brought under this same claim. It's the same type of garbage, saying, well, it's a constitutional loss. Our rights are being infringed. There's no other remedy anywhere else. And they're suing on these bases with other things attached too, but major claims. We've talked about this statute a lot. Supreme Court says, okay, he says they're going to win. And it's based on that law because that's what they're suing under. So on March 26th then, Trump's government filed this application to vacate the judge's lower order and to request an immediate administrative stay, which is what they're deciding now. Although the courts of appeals generally lack appellate jurisdiction over appeals from TROs because they're temporary restraint. They say it's just for like 14 days. Just chill out, okay? Once we litigate this, then you can appeal it up. Once it comes down and you have a some finality after the end, we get to a preliminary injunction, then you can appeal it. But it's too early to appeal. Right? Just like in criminal law, you appeal at the conclusion of the case, broadly speaking. But the Supreme Court says, but it's not a TRO. We can see it just like everybody. They say several factors counsel in favor of construing the district court's order as an appealable preliminary injunction. We can see it hanging there. Among other consideration, the district court's order from Judge Young carries many of the hallmarks of a preliminary injunction, obviously. And moreover, and they're citing cases. So this is like instruction to all the other courts, right? They're reminding, hey, other circuits, if you're issuing a TRO and you're calling it a TRO, but it has the chromosomes of a preliminary injunction, then you should go with the chromosomes, see what those look like. And the case law for that is Sampson and Abbott. So you got to follow these guidelines. If it's a TRO masquerading as a preliminary injunction, we're going to call it out as a PI. So just reminder on that. So everybody who's doing this little game Now you know. Go read Sampson. Go read Abbott. Those are our Supreme Court cases. We decided this one in 1964. We revisited it again in 2018. So stop with the games. Injunctions are injunctions. Now, moreover, Judge Young's basis for issuing the order is strongly challenged, they say, Supreme Court, as the government, Trump, is likely to succeed in showing that the district court lacked jurisdiction to order the payment of money under the APA. No jurisdiction. You can't order what you ordered there because you were, it's a contract. You're ordering the money to be paid. That's not what the APA is for. Hello, saying, hey, judge, the APA's waiver of sovereign immunity, which if you have sovereign immunity, the government cannot be sued. So they say, well, there's a law that says the government waives that, so we can sue you here under the APA. Supreme Court says, no. The APA's waiver of sovereign immunity does not apply if, quote, if any other statute that grants consent to the lawsuit, meaning the government is agreeing to be sued, if that other statute expressly or impliedly forbids the relief which is sought, then you can't come and sue under the APA. Okay. So in other words, if there's a law that says you can't sue for that thing under this statute, then you can't go and try to find another statute or forum or bring that same claim under the APA, right? It's like you can't go from mom to dad. If you go to dad and dad says, sorry, you can't do that, you can't go to mom and she says, well, I'm APA mother, so I guess I'll allow you to do it. No. You're prohibited from that thing. You can't use the APA as a safety valve to just go, well, I can't bring it over here because it's specifically statutorily prohibited, so I'll just use this catch-all claim to bring a claim. Nor does the waiver apply to a claim that is seeking, quote, money damages. Look at the law. 5 U.S. Code 702. Now, it's true, right, which is what we're talking about. So the judges are calling this out specifically. These are contract claims for money. No, they're saying, no, they're not. They're equitable claims to just return the contracts to their status quo position. So you mean you want specific performance to reinstitute the contract? No. We just want them to turn the auto pay back on. Okay, so you want money, is what you're saying? No, we just want the check boxes to be re-on. So the money goes into your account, right? Yeah. Got it. So you want money damages, yeah. True. The lower court said, well, just because there's a possibility, this is what the lower judge, just because there's a possibility that there might be money that results in this case, right? The judge is saying, well, I'm ordering a return to the status quo. So what? They're getting money, but that doesn't make this a contract claim. I'm just returning it to the status quo because these are constitutional violations that caused a problem here. They say, well, but as we've recognized, the APA's limited waiver of immunity does not extend to orders to enforce a contractual obligation to pay money. Derp. Hey, dumb, judge, look at this case called Great West Life, issued by the Supreme Court in 2002. You can't force money payments under the APA. The Tucker Act, not that Tucker, grants the Court of Federal Claims, which how many times have we screamed that here? The Court of Federal Claims has jurisdictions over suits over any express or implied contracts with the United States. You're in the wrong courtroom, okay? And this is everywhere. So we've seen there are hundreds of cases that have been filed now. A good portion, I'd say over 50% of them, have some sort of an APA claim wrapped up in there. And most of these are contract claims. Even Perkins Coie and all these people, where our rights are being violated. Although I don't know if they came under the APA with theirs specifically, but many of them are saying, right, our rights are being violated, and these are contract cancellations. Trump has every right to cancel these things. And if they want to complain about it, it's already in U.S. code. Go sue in the right court. You can't go forum shop for certain judges. Now, as for the remaining state factors, this is the Supreme Court writing. The states have not even refuted the government's representation that it is unlikely to recover the grant funds once they are dispersed. Remember this concept too. Once the money goes out of the government bank account, it's gone forever. They're not going to get it back. And so our response, well, issue an injunction bond, make them post some money up so that they have some skin in the game, so that if Trump is successful, as these cases appeal up through the courts of appeals and into the Supreme Court, if Trump is successful, we get the money back. Otherwise, the taxpayers are on the hook. Once these funds are gone and paid out to all their Democrat grifters, they're going to dump them back into their politicians' hands, and we're never going to see a dime of it. So they say there's no guarantee that the government is going to get any of it back if they win. So that's why they want a stay, because that money will be gone. And the judges, in response to the demand for the injunction bonds, has been to just make a nominal injunction bond of $100. And, well, it's just enough. That's fine. They don't have the funds to come up with it, and this will secure their appearance. So the Supreme Court continues, no grantee promised to return the withdrawn funds should its grant termination be reinstated, right? So in other words, states, you have not promised to give the money back, and the district court inclined to impose a bond. So by contrast, the government compellingly argues that the respondents would not suffer irreparable harm while the TROs are stayed, right? They've represented in this litigation, the states, that they have the financial wherewithal. They're going to keep their programs running. So if respondents ultimately prevail, the Supreme Court says they can get back pay, okay? They can just go sue in the Court of Federal Claims and get damages. They say, we're owed $10 million. Okay, go sue over there and claim it. Then you can get it. But you don't need a stay that stops Trump from doing all of these changes. And if respondents instead decline to keep the programs operating, if they want to eliminate the programs, then any ensuing irreparable harm would be of their own making. So if they want to cancel everything, then that's fine. They've already explained that there is no irreparable harm. So that basis from Judge Young is not good. So such self-imposed costs are not the subject of an inquiry on a motion to stay, right? If they say, well, we have to wind down our services, well, that's your prerogative. Make that decision. If it's not worth it to you to fund these things, the federal government was funding, then close it. So the Supreme Court says, we construe the application as seeking a stay pending appeal and grant the stay. On March 10th and the March 10th order and the March 24th extension from the lower level judge from Massachusetts is stayed pending the disposition of the appeal in the United States Court of Appeals for the First Circuit. So this is like a roadmap back for the Court of Appeals to say, hey, we don't think there is any irreparable harm. We don't think that there is any really merits to their claim under the APA, and we don't think the district court even has jurisdiction here. So it's like a guideline for the Court of Appeals to dismiss this case. And disposition, so says it is stayed, and disposition of a petition for writ of certiorari, if it is timely sought. Now, if the Supreme Court denies cert, the stay shall automatically terminate. And in the event cert is granted, the stay shall terminate upon the sending down of the judgment of this court. Okay, so he's basically given like a if this, then that, if this, then that. But we're going to the First Circuit. Everything is on stay until the First Circuit disposes of this. If the First Circuit does not dispose of this, Trump will go to the Supreme Court. If the Supreme Court denies cert, then the stay is terminated, right? We know, the Supreme Court's not acting on it. That judge is right. It can be allowed to exist. If the Supreme Court grants it, then the stay shall terminate when they send down judgment from the Supreme Court, this court, which would, of course, coincide with the judgment. So we have the rest of it fleshed out. So this judge is now stayed, Judge Myung John from South Korea, now serving in the District of Massachusetts, who wrote an order that prohibited everybody in the Department of Education from doing anything and ordered everybody to go back to the status quo. So it's very clear that they're amazing and, it's clear on the merits and they have irreparable harm and boo-hoo-hoo, all the things. He was scolded and reversed by the Supreme Court. And what is so nice about this is hopefully all of the other circuits, all of the other districts get the memo. These APA claims are garbage. Your contract cancellations were never entitled to you. You don't get to enjoy the government teat for all eternity. Go find another source of income. Stop suing and trying to make constitutional claims. The American people have said enough already. Go find something else to do. And thank you for your attention to this matter. The Supreme Court dropping a good one. And I think this is the beginning, right, of some solidarity on how the court will address these one at a time, piecemeal. I don't know why they chose this case specifically, but they did, and it should have reverberations throughout the rest of the cases we're covering here. So we'll keep our eye on this. Thanks for joining us and subscribing as we do. All right, now let's talk about some other affairs that are happening out there. And this is another good one. A federal judge ordered this guy to come back to the United States. He's currently in El Salvador, was deported by the Trump administration, and she said, bring him home, put him on an airplane, and get him back ASAP. We remember Trump deported a bunch of people based on the Alien Enemies Act, and we talked about this guy before, saying that he was scheduled for deportation, but was not supposed to be deported specifically to El Salvador. So the question really becomes, is Trump, one, going to bring this guy back? And does he have to bring him back? Or can he just move him to another country that is not El Salvador, based on the orders from all of these courts? Now, we've talked about this case before. It's Kilmar Armando Abrego Garcia. The judge who ordered him to be flown back into the country is this woman here. Her name is Paula Zinnis from Maryland. And it's interesting because I looked up her record and her background. And of course, she was a Democrat appointee, but she was also somebody who sued cops, which is curious because the reason these guys were deported was because they were Tren de Aragua alleged gangbangers. And of course, everybody's claiming that's not true. They're innocent barbers, and that's all they do is want to make America great. So here what's interesting is Jeff Sessions, back when this nomination was happening, said she was in a private practice of suing cops, alleging police brutality. Zinnis was most recently with the Baltimore law firm who represented the family of Freddie Gray, 6 Baltimore police officers charged in connection with that. And she made a ton of money, right? $6.4 million in a settlement there. She built a career, someone said, out of suing the police, and has shown a lack of understanding of the reality of law enforcement, which is probably why she's bringing back alleged Tren de Aragua people back into the country, like, oh, bring them back. Says it's critical that we have judges that respect the rights of the accused, but also law enforcement, or the American people. President Obama appointed this woman, and everyone says she's eminently qualified and so on. Now, I'm not so sure that she had any prior career as a jurist, but we'll come back on that one. But there was a hearing. A federal judge, Zinnis, ruled that the United States must bring back this guy. The Trump administration conceded in a court filing that it deported him because of an administrative error, which is kind of being taken out of context. It's like deported him to to El Salvador because of an administrative error. The deportation itself, not necessarily the administrative error. It was the error that he went to El Salvador. He could have gone to any other country, but said it could not bring him back because he's in custody down there. So in the hearing, which took place today, it appeared to mark the first time that they admitted an error, which again is an error between the countries. So there was some testimony about what happened here today. It says, the judge said, this case is certainly important to Abrego Garcia and his family. So in recognition of that, this judge says, I feel like I can't wait on giving my order. I can't wait on it. So over the course of the hearing, the judge had repeatedly raised issues with the removal to El Salvador. Said, well, an immigration judge had previously granted him withholding of removal to El Salvador, meaning he could suffer prosecution in El Salvador. He was still considered removable, right? That's the thing. So he could have been deported, but he just couldn't be deported to El Salvador. And the error was he got sent to El Salvador. Now, Zinnis cited the status of her ruling, saying that he was apprehended last month without any legal basis and was deported without justification of any legal basis, which is not true. We covered the documents. Multiple judges explained that he was, and he didn't show up to court that one time. Now, this was an illegal act. Congress said you can't do it, and you did it anyways. The Department of Justice attorney, Irez Ruvini, conceded to Abrego's attorneys that he should not have been deported to El Salvador. Says our only arguments are jurisdictional, okay? He should not have been sent to El Salvador. Now, Zinnes, an Obama appointee, questioned why the U.S. could not bring him back. Why can't we get him back, she said. Well, the first thing I did when I got this case on my desk, said the DOJ lawyer, is I asked the same question. The answer I got back is not satisfactory. She's like, I don't know. El Salvador's not talking to us. All of this points to a functional control, said Zinnes. Ruvini called his own lack of information on why they couldn't bring him back frustrating as well. The United States can't call someone in El Salvador and just say, give us this guy back. So the DOJ lawyer appeared to suggest that he had asked the government to return Abrego, but they did not heed his advice. He then asked the judge for 24 hours, but it was unclear what the request was for. So another lawyer for Abrego asked the court to order his client's return to the U.S., saying he isn't asking for micromanaging by the court, but the government needs to be put on a leash, he said, to ensure this is done in a timely manner. At least today, it doesn't seem like they're taking it seriously, Sandoval Moschenberg said at Ruvini's arguments. Now, during the hearing, Zinnes also appeared skeptical about the alleged ties to MS-13, which Trump officials have maintained, saying he has not seen sufficient evidence. She has not seen sufficient evidence. Saying when someone is accused of membership in such a violent and predatory organization, it comes in the form of an indictment or complaint or some other robust process. Yeah, right. Robust. Like the 4 times you tried to get Trump. The government made a choice here to produce no evidence. And so they said that this person, there's not sufficient evidence of this. And I don't remember if this was the guy who didn't show up to court or if that was another person. So I want to be clear that we're not misstating that. But we did read through, I think it was Will Chamberlain's thread on this. And he gave us some great details. This guy had plenty of process. And the only withholding was about El Salvador. And also, Will Chamberlain went into the follow-up on that and said, in hindsight, El Salvador has been reformed. So the basis that the judge used for withholding to El Salvador was about the pupusas. Remember? Pupusa guy. And the pupusas should no longer be in threat because El Salvador has cleaned up the pupusa problem now. So there's no risk to being returned back to El Salvador. So the basis for the withholding is really now moot. So the order came down from the judge. She says, fly him back, bring him home. She wrote the following from Judge Paula Zinnes. Says, the court has reviewed the motion from Kilmar, which is a perfect name for an alleged MS-13 member. Kilmar. Great. Says the court has reviewed plaintiff's motion for an injunction and the memo and the briefs. And Kristi Noem, who's named as the defendant here as well. I've read everything. The judge writes, well, Kilmar is a native of El Salvador and was granted withholding of removal in 2019, which this prohibited his removal to El Salvador. Now, the record reflects that Abrego Garcia was apprehended in Maryland without legal basis on March 12th, she says, and without further process or legal justification was removed to El Salvador on March 15th. Now, I'm sure Trump disputes that. Abrego Garcia is detained in the Centro de the CICOT Center, and they contend his removal, his lawyers, violated the Fifth Amendment and U.S. Code and the APA, right, there it is again, and other applicable legal protections. So this judge, appointed by Obama, who used to sue the cops, says, well, based on the record before the court, I find that this court retains jurisdiction over this. And I believe that they're going to win on the merits because this person was removed to El Salvador in violation of the Immigration and Nationality Act without any legal process at all. We read through it. His continued presence in the El Salvador for obvious reasons constitutes irreparable harm. You hear that, Nayib Bukele? She's talking garbage. Now, the balance of equities and the public interest weigh in favor of returning him to the United States, and the issuance of a preliminary injunction without further delay is necessary to restore him to the status quo and avoid the ongoing irreparable harm from his removal. And so for these reasons, the court directs defendants to return Abrego Garcia no later than April 7th, 2025. All right, so this is spicy. So they're going to have to, the DOJ is going to have to go into overdrive, right? Go into that and really communicate with Bukele and try to get this guy back, right? Saying, accordingly, a memorandum opinion, if they want to comply with this, a memorandum opinion further sets forth the basis of this ruling. So she'll release that later. Saying, accordingly, it is the 4th day of April, and so she now orders that the motion is granted. So Trump and Kristi Noem and the rest of Homeland are hereby ordered, Rubio, everybody, to facilitate and effectuate the return of plaintiff Kilmar to the United States no later than 11:59 p.m. on Monday, April 7th. So get him on an airplane and get him back home right now. The preliminary relief is issued to restore the status quo. This judge has now taken over control of foreign policy, and this is a non-citizen, by the way, not even close, right? To preserve Abrego Garcia's access to due process in accordance with the Constitution and governing immigration statutes. The clerk is directed to transmit the orders to all the parties. Wild, right? The judge saying, get this guy back in the United States by Monday at midnight or else. And we remember, right, this is the real story from Will Chamberlain. Just want to make sure we are familiar with what we're talking about here. This was the guy who had multiple proceedings. Here's the document. Bond proceedings. Respondent Kilmar, Abrego Kilmar Armato, is a native. He's a not a citizen or national. This was in 2019, okay? What are you talking about? He's a native of the citizen. He arrived at the United States, judge. He is not admitted or paroled, and he's an alien present without being admitted or paroled. He was held in custody by Homeland. Now, the finding that he was a member of MS-13 came up because he asked for bond. Right there. Here it is. Immigration judge reviewed the evidence and found it showed he's a verified member of MS-13. It says right here. Therefore, Abrego Garcia did not demonstrate that he could be released from custody. After considering the information by both parties, the court concluded that no bond was appropriate. First reason, he failed to meet the burden of demonstrating he would not be a danger, as evidence shows that he is a verified member of MS-13. There's your due process, judge. Did you miss it? You should follow Will on X. The BIA held that this form is inherently untrustworthy, trustworthy and admissible. The respondent says that he erroneously states he was detained in connection to murder. He also claims that this contradicts this, and it does appear at odds with the gang field interview sheets. Okay, so this guy's like lying. The reason for the arrest given on his form does appear at odds with the gang field interview sheet, which states that the respondent was approached because he and others were loitering outside Home Depot. Regardless, the determination that he's a gang member appears to be trustworthy and is supported by other evidence on the record. So how come this judge found that, but the other judge found differently? Oh yeah, the immigration judge also found that he was a flight risk, noting that the history is he's failing to appear for proceedings pertaining to his traffic violations. Yeah, that's right. It was the guy who failed to show up to court. He's a flight risk, right? Yeah, there's so many, I can't keep track of them. But yeah, it didn't show up to court. So no, you're not going to show up. We're not going to release you. This judge ordered what another judge, Elizabeth Kessler, shout out to Elizabeth, a good finding. This judge just overruled, basically. Says no evidence that this guy's a flight risk, no evidence that he's MS-13 and he was unlawfully arrested. What? Abrego appealed to the Board of Immigration, which affirmed the judge's findings. He got an appeal. That's how much due process he got. And they dismissed the appeal. Fast forward, he filed another claim, right? Got another immigration lawyer making trillions right now, and sued, said, and fought for another claim for asylum. That's when he got the removal to El Salvador prohibition because of the pupusas. Pupusaria Sicilia. Their pupusas were getting obliterated down there in El Salvador, and he fled the country. He's like, they're wrecking my mama's pupusas, so I'm going to go to America. What a great son. So he got plenty of process. Here are the documents, okay, Judge? You should read them and then revise your ruling accordingly. But she ordered him back into America because that's what the Democrats are doing right now. And I guess we'll see what they do. We'll see what happens, whether they go into the El Salvador prison, whether they can bring him home. And they got to do it by Monday, or this judge is going to do the same thing that they've been trying to do in other jurisdictions, which is try to hold Trump in contempt, just like Judge Boasberg is maybe going to do, and just like she's trying to do, right? It's a contempt trap that will lead to an impeachment trap as they instigate a so-called constitutional crisis by stepping way outside of her jurisdiction. This guy got plenty of process. And really, she's lying, right? To come back in her opinion and drop something so ridiculous, saying he got no due process. He was apprehended without legal basis. We just read it. And was deported without further legal justification was removed. It was all justified right there. Other immigration judges found for it. This is the same guy. Am I crazy? Kilmar Armando Abrego Garcia. And this is what Will Chamberlain shared with us right here. Same dude. Kilmar Armando Abrego Garcia. All right, just making sure that we can read because apparently the judge can't. So we'll keep our eye on this one. Obviously, the Democrats are trying to turn this into something. They went down to the border, and Bill Malugin, who reports for Fox, was sharing this with us, says the delegation of House Democrats visiting the southern border today will hold no public events, and their visit is closed to press. They finally go down to the border. Now, a Border Patrol source just sent me this photo of Benny Thompson. Look at him. Benny Thompson. What's he doing down here? Is he going to go visit the border? Or is he like going to the casino or something? I don't know what he's doing, but said he's there. They're at the Chula Vista Border Patrol station, reached out to the Democrats to inquire about covering the visit. As of other media outlets, we were told it's not public. Sorry. Their visit is to conduct oversight of the Trump administration's border policies. We're sure. All right. So here was Homeland spokeswoman called Tricia Ohio explaining what the truth is about this Kilmar fella.
People should know who this individual is. He's not some Maryland father, as the mainstream media will make you believe. He's actually a member of MS-13 and was involved in human trafficking. It's unbelievable, the framing of this. Whether this man is in El Salvador or in a U.S. detention center, he should be locked up. And people should also know who MS-13 is. It is a gang that rapes, maims, and kills Americans for sport. They should not be on U.S. soil, and any media outlet who tries to make him a darling or a victim should really be ashamed, because the American people do know better. The American people.
Well, Judge Zinnis and Boasberg and the Democrats and all of the mostly Democrat-appointed judges want them in our country. They care more about their due process rights than they ever cared about the J6ers or the pro-lifers or anybody who was trying to survive during COVID. They didn't really care about any of our rights. But if you're a Tren de Aragua gangbanger, half the ACLU will come work for you for free. Here's Representative Wesley Hunt from Texas.
I want to start by saying this. I'm a military guy, a West Point guy, and General Patton famously said, either you lead, follow, or get out of the way. President Trump has led on this issue. The country has followed, and those that oppose securing our border must get out of the way. And let me be clear. For the past 4 years, basically, the Democrat Party has obstructed what's happened and progress at the border. Keep in mind, they opposed H.R. 2 that we passed out of the House 2 years ago. Their borders are Kamala Harris never went down to the border. Then they blamed us for not securing the border toward the end of his term. And then guess what? Abracadabra, snap of his fingers with the signing of a few executive orders, the border gets fixed. And then now they want to go to the border because they lost on this issue back in November and they have no leadership. So what are they going to see at the border? A fixed border, because President Trump fixed it in the last 6 weeks and they should have been there for the past 4 years. This derelict of duty costed them this last election. And then now they're trying to clean up on aisle 4, but it's just too late.
It's too late for them to try to clean up this mess. Trump is going to take care of it. It would be nice if they would just let our country get rid of gang members in America. I don't know why they have to fight us so hard on this, but we hope the American people are watching who they are, who they're standing for, and who they're fighting for. And don't forget it. All right, so let's carry on and talk about this judge. Judge McConnell. This is a fun one because he's, this is a ridiculous one. Judge McConnell is furious at President Trump. The delay and the bureaucratic compliance strategy that the Trump administration has been deploying is working, and they're not liking it. Remember, this judge A lot of concerns about him. Judge John McConnell, appointed by Obama, has some very questionable relationships with some nonprofits and NGOs and has been ordering all of Trump's rescissions and his cancellations of contracts to be reinstated. And this is the case about that FEMA money that Trump canceled. This judge ordered it back. And what is happening in this filing, you can see they sued everybody. Look at all these defendants here. Everybody got sued. What is happening here is this judge is ruling on a motion for enforcement. So in other words, the judge said, give them their money back. Trump said, well, okay, we'll work on it. We're going to work on it right now. We're going to get the checkbook, but it's down stairs on the first floor, whatever it is. So we got to go get the checkbook. And before we can give them their money, we got to get the checkbook. And then when I got the checkbook, we ran out of checks. Don't you hate that? Got to order some new checks. And then once you get the new checks in, we wrote the check, but we put in the mail and we forgot to sign it. I know. So it's very complicated. The bureaucracy is massive and monstrous, okay? And things are hidden in nooks and crannies and tucked away in Nancy Pelosi's butt cheeks. No one knows where it is. So if we want to get the files, we got to get them out of the cave. It's cavernous down there. So it's just complicated. So it's been slow. They say turn the money back on. And now they're saying, judge, make them do it. Enforce this. So the judge then issued this order and says, listen, okay, on January 31st, I, Judge McConnell, entered a TRO that stopped President Trump from pausing the money. And I instructed Trump shall not impede the state's access to this money. Now, the TRO also stated that if Trump engages in other blocking of these funds, you need to let me know about it. Now, within weeks after the court issued the TRO, the states, all the blue states, continued to experience freezes of their money, of numerous grants and awards that went unresolved, even after talking with the Trump counsel. So the states filed a motion to enforce this. Give us our money right now. And the court granted it, ordering Trump to immediately restore frozen funds, immediately end any funding pause during the pendency of this, and immediately take every step necessary to effectuate the TRO. And Trump's like, oh, we're working on it. We're trying, dude. It's a mess. Nancy Pelosi's been running this thing for 50 years. No one knows where she hid everything. We're trying to find it. Eventually, the states filed a second motion to enforce, saying the states are also facing obstacles. We're still not getting our millions that were awarded, and we're obligated to come from FEMA. And they asked the court to order FEMA to give us our money. 1-800, I need my money. I want it now. On March 6th, the court issued another injunction ordering that FEMA was stopped. You have to give them your FEMA money too. Now, because of the court's issuance of the injunction, we issued the preliminary injunction, meaning the TRO was expired. The court denied the second motion as moot. Now, still the court ordered FEMA to file a status report. FEMA filed the status report. And the states responded. They said, they're still not giving us our money. So now the states are coming back and they're saying, make FEMA give us the money. So this judge is saying, whoa, so this might be civil contempt. I don't know. So I'm not happy about this. There might be civil contempt here. Did you have notice of what I told you to do? Was my order clear and unambiguous to get them their money? Did the contemnor, in this case Trump, have the ability to comply? And did you violate it? Maybe holding Trump in contempt? The states say that they have not received a substantial disbursement of our money. They highlight that these funding disruptions coincide with Stacey's email that was sent to all staff on February 10th, which said, put a hold toggle in financial hold on all that FEMA government money. But the states have been sitting here like, hey, where is it? The processing of the awards has yet to come. In fact, Hawaii said, we need $6 million from FEMA. Well, they did have that fire, you know. Oregon wants that money. We haven't gotten FEMA funds. What happened in Oregon? $129 million for what? Climate change? None of the Colorado DPS money came in. $33 million for what? 14 grant programs have been approved. For what? Notice they're all blue states, right, who are complaining. Rhode Island's FEMA grants, which support nearly a dozen grant programs, have been unavailable for more than 30 days. For what? More, Arizona, which was blue, California, Colorado, Hawaii, Illinois, Maine, Maryland, Michigan, New Jersey, all of them have their FEMA monies frozen. So the states contend that at least 215 FEMA grants to at least 19 plaintiff states remain frozen or inaccessible. What are all those national emergencies? What are those happening? Is this why they don't have money when North Carolina burns to the ground after a hurricane obliterates the whole region? Is that why? Because it's going to Vermont for climate windmills or something? I don't know. Now here, thus the states allege that FEMA's implementation is appropriate. And so this is Trump's strategy on display. Trump says, hey, we're following FEMA's manual review process, okay? And it's not a pause or withholding. It's simply an internal control. We're manually reviewing all the grant payment requests before dispersing the funds. That's all. And by the way, Cameron, shout out to Cameron, acting FEMA administrator, he says, I'm reviewing them manually, personally, in response to Kristi Noem's order. And thus, on February 14th, Valentine's Day, Mr. Hamilton formalized the ordered review process, issuing guidance. He says that the review of this payment is not the type contemplated before. And so we're assuring that there's not any waste, fraud, or abuse as we're reviewing these payment requests. So we're following the law very deliberately. Further, the defendant asserts that this manual review process is not violative of this injunction. Your Honor, you said that we could rely on our own independent authorities to implement this process. So we are. We're not even following the directive. We have an obligation under the rules, okay? Strict compliance with the rules. When it comes to paying anybody out now, ultra strict compliance with the rules. Your Honor, the Code of Federal Regulations says that we have an obligation to manage and administer each award in a manner to ensure it's in compliance with the law, right? We're going to pay them. Hello. We just have to follow the law, like you said. That's all. So we're even doing it manually, okay, to be in strict compliance. But the judge is like, I want you to just turn it all on now. They're like, oh, no, we can't. You said we had to follow the law. Code of Federal Regulations, section 200.300, subsection A says we have to. Now, Trump also highlights that relevant grant regulations dictate that costs must be necessary and reasonable. And so we're analyzing those too. There's another subsection right here. Section 200.404-405. It says we have to analyze those too. So thus, Trump says, these regulations illustrate that FEMA has independent regulatory authority to review payment requests to make sure they're appropriate and lawful before we disperse them. So that's all we're doing. Now the judge says, but this law is general and has nothing in this, which this judge is like, if you do this, if this is a manual review process, basically means there's an indefinite categorical pause on payments, right? Meaning if you go slow and like look at everything, it's basically pausing everything. We're like, yeah, we know. Nor does this mean you can conduct a review specifically like you're doing it. And this section already prescribes on how it works. And so in any event, they presented evidence that strongly suggests that this manual review process is covertly based on Trump's order. Okay, so I said you could find an independent basis and follow the law to do these things. But the way you're finding independent bases and following the law is basically in total alignment with Trump's EO. And it's basically doing the same thing. And so I ordered you to not do that. Secretary Noem's grant directs a hold. Okay, Kristi Noem made a memo. It was a hold. And NGO grants were issued barely a week after the invasion EO. And all of these things got canceled. So the judge says, this feels a little bit too suspicious to me. The temporal proximity between the issuance of the invasion and the OMB memo and the NGO grants further illustrates it's a pause. And so it feels like, this judge says, you guys did all this stuff very coincidentally, one after another. And it's like, Judge, we've only been here for like 100 days. Okay. So yeah, like there's a lot happening. That's why they're happening quickly, because we're getting stuff done. You're welcome. He says, so it feels like Mr. Hamilton's assertion that the manual review process was implemented in response to a memo means that the review process was implemented to comply with the EO. And because I've already said the EO is now prohibited, this must also be prohibited, telling us the court reaffirms its preliminary injunction order, saying that Nome is enjoined from pausing, freezing, blocking, canceling, suspending anything based on the directive, including any other freezes dictated, described, implied, or before the rescission, or any other, materially similar memo, directive, policy, or practice. Even the practice. So now you're looking at these things independently, and anything that results in a categorical pause or freeze of the money that comes from Congress. So this judge is so scrambling, right? So I said you could do this, and this has happened time and again. We did this with USAID. If you have an independent basis, go use it. Trump says, totally fine, perfectly. We'll use our independent basis. We'll pay out only certain people, and they follow it. The judge freaks, has to expand it. And again, it's showing us the unreasonableness of the judiciary. This is the judge acting insane by saying, what? Trump can't pause any money at all under the executive branch or make any of these changes. He's got to restore everything to the status quo. Saying FEMA received notice of this, the record makes clear that FEMA's manual review process, which is this bureaucratic compliance, strict bureaucratic compliance. Yes, Your Honor, we're going to follow the law, 100%. Well, basically, this manual review process that is literally following the law is akin to an indefinite pause on the disbursement of the funds. And this is all based on Trump's EO. Trump did this. And you're basically doing what Trump said to do, even though you're not following the same process that Trump said to follow. Wild, right? Now, throughout the duration of this injunction, FEMA must immediately cease the manual review process. So you can't even look at this manually now. And basically turn everything back on. Immediately comply with the injunction. Don't impede the money going to the states. And direct this order to anybody who orders these things within 48 hours after this order, signed by Judge John J. McConnell, Jr., a Democrat judge who has some very interesting connections with some boards out there that get government money, maybe even FEMA money at Crossroads, Rhode Island, and more. So we're going to keep our eye on this case. Trump, of course, wants these judges gone. I think many of us do. And so one person a representative called Mr. Clyde, introduced this resolution to impeach Judge McConnell. Here's what he wrote. He says, articles of impeachment exhibited by the House of Representatives are now introduced, calling this an abuse of power, saying Judge McConnell of Rhode Island knowingly politicized and weaponized his office to advance his own political beliefs, saying the Constitution and the House of Representatives have the power of impeachment, and the separation of powers means the president has broad authority over the executive branch, which includes control of his departments. Now, this Judge James McConnell Jr., engaged in actions that prioritized his own political views and beliefs over his duties of impartiality. He has spent his entire career displaying his political views and beliefs in his financial contributions as well as his public comments. Here are some examples. Judge John James McConnell served as the director of Rhode Island branch of Planned Parenthood. And Chief Judge McConnell Jr. and his wife contributed $700,000 to Democrats. Maybe why he became a judge. Got that nomination, right? You can pay off the Democrats and they'll nominate you. Chief Judge John James McConnell Jr. has allowed his personal political opinions to influence his decisions and rulings, and he's made an array of public comments clearly demonstrating his bias against Trump. In January 2021, Judge McConnell made public comments stating, "We fall back on kind of a stereotypical comment that judges should have no opinions and whatnot." And that's just not true. Obviously, they have opinions. We see it. Now, Judge McConnell also made public comments that equated Trump and his first term as president to the Civil War and Jim Crow laws, and even likened him to a tyrant. McConnell also made a public comment in January 21 that when sentencing, he says, the law applies to them where they are, for criminals who are women, black, or transgender. So the law applies differently. If you're black or trans, you've got more victimization because of white dudes, and now you get lesser sentences or something. McConnell also made public comments in January 21 stating, when you're sentencing someone, that you have to take a moment and realize that this, this middle-class, white, male, privileged person needs to understand the human being who comes before us, that may be a woman, or may be black, may be transgender, may be poor, may be rich, maybe whatever, may have experience but not yours, and may have to walk in their shoes and understand that the law applies to them where they are, and then you have to apply the law accordingly. Oh, man. That is like the worst type of judge you've ever seen, right? So different penalties for different people depending on your physical characteristics. What a sick person. What's that blindfold doing on Lady Justice for? I'm not real sure. Chief Judge James John McConnell made public comments in January stating, "We have formed a committee to look at race in our court. Have we given disparate sentences between blacks and whites about hiring practices?" Maybe. It sounds like white. If you're white there, it sounds like you're in big trouble. Chief Judge John James McConnell Jr.'s financial contributions and overt public comments clearly demonstrate a political bias that would impair his ability to make a fair judgment regarding his actions. Now, where McConnell now is found guilty of high crimes and misdemeanors, he should be removed from office. He's also got conflicts of interest. Saying, while serving as a chief judge for the United States District Court of Rhode Island, he had a major conflict of interest that prevented him from being impartial in the matter of New York versus Trump. There is substantial evidence that James McConnell Jr. serves on the board of directors for a nonprofit organization called Crossroads Rhode Island. Yep, was chair of the board from 2011. And they've confirmed that he has stepped down from the board. And he was on it, but he stepped down, I believe, in 2024 after it became a problem. Now, according to Crossroads Island's tax filings, he has appeared every year as a director of the organization since he took the federal bench. And according to Crossroads tax filings for 2023, its total revenue was $30.6 million. And guess where that money came from? $18.6 million came from the government, including from Rhode Island. And so this guy is ordering the spigot of FEMA to be turned back on. And they're spending, as we just saw, tens of millions of dollars in a bunch of blue states all across the country. Go figure. In fiscal year 25, Crossroads Islands had already received $2.8 million from the state government of Rhode Island, right? So if the FEMA money goes to Rhode Island and Rhode Island sends the money to Crossroads, that's a conflict from the judge. The state government of Rhode Island is a named plaintiff in the lawsuit against Trump. And his administration, and he's presiding over that. Yeah. And Chief Judge James Roberts stated that all the states rely on federal funds to provide and maintain vital programs and services, right? And then his organization gets it. There is a clear conflict of interest given that Chief Judge John James McConnell presided over and made a decision regarding a case which significantly impacts the funding of an organization where he serves as a director and as a fiduciary. And I think he stepped down from, there's multiple boards like board of advisors, board of directors, and so on. And they might have shifted him around recently. The code of conduct for judges states a judge must avoid all impropriety and appearance of impropriety. This applies to both professional and personal conduct. A judge must expect to be the subject of constant public scrutiny and accept and willingly any restrictions that are upon him. And the U.S. Code also requires that any justice, judge, or magistrate judge of the U.S. shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. And the U.S. Code also requires judges must disqualify themselves from a proceeding when he knows that he individually or as a fiduciary or his spouse or minor child, if they have a financial interest in the subject matter that is before them, they are conflicted and they need to go. Now, this judge has a serious conflict of interest. He got money for his organization from Crossroad, Rhode Island. Rhode Island is a party to this lawsuit, and that is a conflict. He should have recused himself. He didn't. He should have immediately recused himself, and now he didn't, violating his duty of impartiality owed under federal law. He's guilty of high crimes and misdemeanors, and he should be removed from office. And that is a solid article of impeachment exhibited by Mr. Clyde and McConnell, one of the worst, who is clearly a Democratic operative put in place after donating $700,000 to them and doing their bidding. So we'll see what Congress will do about this. We got Speaker Mike Johnson, who is right now very busy with the budget, talking about the border, talking about energy, talking about spending. We'll see if they can maybe defund these judges while they're at it.
The Republicans in the House and Senate are completely united on this mission. We must accomplish the mission, Larry, because the big, beautiful bill is going to get the economy rocket fueled again. I mean, this is how we're going to get the economy going. It's going to settle the bond markets and the stock market, I believe, because it will show that Congress is serious about reducing debt and the deficits. But also, the reason it'll be rocket fuel to the economy is because all the elements of it. We're going to do American energy dominance again. We're going to secure the border and do those basic things we promised on the campaign trail. But also, we're going to ensure we don't have the largest tax increase in U.S. history. And allowing job creators and entrepreneurs and risk takers and companies to know what their tax rate is going forward is a really important part of that. They need stability. They need this to be settled. And so we'll get that done, and we'll get it done quickly. My timetable is try to get it done by Memorial Day so the president can sign it into law as soon as possible, because I think this is going to be the solution to a lot that what is ailing the economy right now.
All right, we'll see if they can get it done. But at the moment, Congress is working on spending. We're focused on the president getting his agenda passed in another domain, in the judiciary. And we're hopeful that we see success on both fronts. We'll keep covering it. Thanks for subscribing and joining as we do. All right, my friends, we got one final update on the day. And look at me, I'm marking up the documents before we even get there. Gosh, getting carried away today. It's Friday. All right, so we've got another one from the president. President Trump appeals another one. This time, we're taking the state of Maryland up to the Fourth Circuit. Bunch of blue states sued the president here, and Trump is now asking for a stay pending appeal, saying, take their lower level injunction, don't impose it upon us, let us litigate this and let us do our job while this case proceeds. Now, this case is taking place out of the District of Maryland. It's on appeal from the District of Maryland. The judge who issued the lower level order is James Kelleher Bradard, another blue judge, of course. Here is what Trump's DOJ is submitting to the Court of Appeals in this case, and it involves a bunch of those fired probationary employees. One of Trump's major executive orders was to increase efficiency in the government, well, in multiple different orders, right, multiple different domains. And one of the initial findings was that if you just got hired and you're in this probationary period, we don't need to keep you here, okay? It's a temporary trial period. There's no shackles that require us to continue to employ you, and so you're all just fired. So the state sued. The lower level court entered an injunction saying reinstate thousands of these probationary employees. We've talked about these cases here before. This was across nearly 24 federal agencies. So they're all fired. They all packed their boxes and left. Now they're all having to come back. Trump says, what? We're going to win this. They're fired. So just stop them from having to come back. Now that injunction follows a TRO. And this relief would be extraordinary, they write to the Court of Appeals. Look, this is wild. It's all the more extraordinary here where the court acted at the behest of several blue states, but not even one affected employee was a part of the lawsuit. the states are suing on behalf of people who actually have the complaint, but they're not a party to the lawsuit. And the states are making their lawsuit on the basis that the employees didn't get the proper notice before they were fired. But the people who didn't get the right notice are not suing. So they say this court should deny the injunction, right? This is ridiculous. The district court from the lower level lacked jurisdiction to superintend the executive branch's employment relationships. The states are not even a part of these relationships. They lack standing to complain of some downstream economic effects caused by the government's firings. They can't come in here and repackage their injuries as informational. That's a dead end for them. Indeed, there is no connection between the purported informational injury that they assert and the sweeping reinstatement of the rehiring of thousands of probationary fired people. Moreover, Congress has channeled already. They've already passed rules. All federal employment disputes have to go into an administrative process with judicial review in the federal circuit. If you allow states to circumvent that process, that would upend that reticulated statutory scheme, and it would contravene the Supreme Court precedent that says where an exclusive remedial scheme permits claims, it shuts the door to claims by anyone else. So go file here because you can't file over here. Now, the lower level judge totally screwed this up. Under federal law, a probationary employee may be terminated. All they got to find is the employee has failed to demonstrate his qualifications for continued employment. Now, the lower level judge believed that the government had not identified sufficient cause for terminating these employees. Well, that's not a good enough reason for that judge. Itself a remarkable conclusion for a judge to even write, to reach in litigation. The employees are not even here. Like the judge, the states and the judges are complaining on behalf of employees who didn't even sue. They're not even a party to this lawsuit. But it didn't stop there. Instead, the judge said that since the government did not have cause for firing these employees, it must have actually, right? They said, well, yeah, you actually conducted a RIF, a specific type of procedure that must give notice to the states, right? So you didn't actually just do a termination, you did a RIF. And since you did a RIF, you have to provide notice. So, well, we didn't do a RIF. Yes, you did. And so now you're in violation of the law. Okay, but even if the court were correct that the government lacked sufficient cause to fire these probationary employees, it doesn't mean it's a RIF. It would just mean that the employees could challenge their terminations through the other mechanisms that Congress already created. So the remaining factors support us as well, Judge. The court's order is an extraordinary incursion into the executive branch. The injunction requires the government to retain and to pay employees whose services it had determined it no longer requires. And there is no mechanism for the government to recoup those salaries if it wins. They're not going to pay it back, particularly given the district court's failure to require the states to post more than a nominal $100 bond, right? That's the injunction bond, $100. Okay, wait. So we have to hire like 50,000 probationary people back and pay them. And if Trump wins, the only thing he can collect from all of those expenditures is $100. Great. On the other side of the ledger, the states don't suffer any harm from the government's determination that it doesn't want to employ their citizens. So to correct these errors, this court should prevent irreparable harm and grant a stay pending appeal. They say, look, the president can fire probationary employees. And we also may conduct a RIF if we want to. The Civil Service Reform Act was created. The FSLM, Labor Relations Act, was created. All these are the rules. We followed them. On January 20th, OPM transmitted guidance talking about probationary workers. The memo directed everyone to identify who were probationary workers. So they did. Then on March 3rd, the government terminated at least 24,000 probationary workers. The states said, well, we didn't get any notice of it. So then the states, 19 states and DC, they sued 21 federal agencies. They said, reinstate these people. And the lower level judge said, yep, all probationary employees, you're rehired. I'm in charge. I run the government. So the government tried to comply. And after another extended TRO, The injunction directed the defendants to undo all terminations by April 8th. Okay, anybody you fired, rehire them. But the injunction is geographically narrower than the TRO, as it only applies to the states. So it narrowed it back to only the states who were sued here. So the district court's legal analysis is very similar to its TRO. The court found that the states had sufficiently shown harms, and the court further accepted that a reduction of their revenues was a real enough harm for standing, right? If they're fired, we're not going to get income. All of those are downstream harms. Now, on the merits, the court found that it was a RIF and found that the injunction was valid. So they ask for a stay. They say, look, first of all, the states cannot sue here. They have no standing. They can't sue the federal government on behalf of their citizens as parens patriae. And the states, therefore, cannot challenge the federal government's actions to fire these people. Instead, to establish Article 3, they must demonstrate they've got an injury in fact. But this injury is ridiculous. Calling it downstream harms to their budgets. Oh, you fired some people and that's harming our bottom line, our budgets. That's a remarkable theory. That's a recipe for any state to micromanage the federal government. And that obviously is not going to stand. They give us some other examples of this. Here, the states assert that federal government's employment actions have inflicted downstream harms. They say terminations or imposing burdens on us. We're going to have a bunch of people sign up for Medicaid. This is going to be a problem. So the district court then repackaged this. They said, well, your injuries are just informational injuries. They're not money damages, because if it was money damages, he can't hear it. So it's informational harm because they didn't get notice of the termination since he packaged it as a RIF. But this is ridiculous. Nor would any informational injury support their relief. The district court suggested that its reinstatement remedy was necessary to remedy this injury, but they cited no authority for how this works, nor may courts grant a redress of this scope and magnitude for a claim like this. Now, they never disputed that if this lawsuit were brought by the employees, so, right, if the employees sued, they would have to go through another court. But apparently the states can bring a claim on their behalf, according to this judge. They say that's wrong. The Supreme Court precedent makes clear that when a comprehensive scheme of the sort at issue here permits review, it is precluded. Your claims are precluded. They give us more examples of this. All of that applies here. It's no answer to say, well, the state's claims are a little bit different. At bottom, they rest on allegations the government unlawfully terminated probationary employees. That's it. They should bring their claims in the CSRA. The state should not be allowed to bring claims on their behalf and circumvent the statutes that funnel their fired claims into the right venue, into the right forum. It usurps that, right? That if you have to go here, then you cannot go there. The states are going over there. The district court was therefore plainly wrong, saying, well, there is no identity of interest between the states and the fired employees. At bottom, Congress did not leave a gaping hole in this to permit fired employees to go have their states sue for them. If you're a fired employee, sue under the CSRA. Congress limited review of this, and the states are trying to exploit it. It should not be allowed. And on the face, it wasn't a RIF. A RIF is a much different thing than what we saw here. He just said a large number of people were terminated, and so that's essentially a RIF. But it's not a RIF. The government is highly likely to succeed in showing it wasn't a RIF, and so our firings are legit. And all of the factors favor a stay, explaining the states have not established any irreparable injury warranting extraordinary relief. We're the federal government. If we want to fire somebody, we can. Making a claim out of downstream economic effects is not sufficient. And so this court should stay the injunction pending the appeal signed by Trump's DOJ. This one is from Stephen A. Myers out of the Civil Division in the DOJ. The rest of this is addendums and appendices. And so that is making its way through the Court of Appeals. And what's interesting is we're seeing this change in the American economy. Joe Biden, when he was in charge, he explained that most of Biden's new employment hires were in the industry of the government. Now that is changing, and we're happy about it. Here is Trump's economic advisor, called Steve Mirian.
You know, one point that I've made a lot is that the Biden administration's last 2 years, almost 3/4 of jobs that were created were in government and government adjacent sectors. And that's profoundly unsustainable to have the government gravy train driving the economy. In the March jobs report, that number came down from almost 75 in the last 2 years of the Biden administration to just about 40, right? So that's a very material decline. And this is part of reconfiguring the economy from a government-driven growth engine to a sustainable, durable private sector growth engine. And this is going to continue. You know,
good developments. We don't need a bunch of bureaucrats in there just wasting time, money, and resources and calling it progress in America because they come up with more boneheaded, brain-dead schemes like, well, whatever they were doing in the sub-Saharan Africa. Don't even know. But, my friends, this is the latest out of the appeal and the fired probationary workers. We're going to keep our eye on it. Thanks for subscribing and joining as we do. All right, my friends. Well, if you're just joining us, let's do a quick recap. We had a great live stream. Happy Friday. I hope your week was successful and outstanding and amazing, and you're feeling accomplished and you're ready for the weekend. We got some major updates out of the Supreme Court today. We did a full analysis on this, fresh out of the oven. I think it's a good, positive order in the right direction. A little concerned about Judge Roberts not joining in on that, but maybe more will be revealed there. Maybe he got a phone call from his BFF Norm Eisen. But anyways, we talked about that. We talked about this judge, Myung John from South Korea, who was involved in the lower level decision. And then we turned our attention to the return of this person, Kilmar, ordered back to America. This woman, Judge Paula Zinnis from Maryland, has said, bring him back. We want him back here. We love Tren de Aragua terrorists. She says there's no due process for him at all. We obviously know that's totally fictional because Will Chamberlain gave us all the documents, so maybe she should read those. But we read through that. We learned what the latest is in her order, saying take him out of El Salvador and bring him back to the country. We then talked about Judge John McConnell, whose conflict of interests are just monstrous and massive. Read why he is being impeached, or why a resolution for his impeachment has been submitted by Representative Clyde, and also saw his order saying that the FEMA money from Trump has to go out. Like, I ordered you to give it out 48 hours. You are delaying disbursement, no freezes, no manual reviews. Turn their money back on. So we hope he gets impeached, or at least removed in some way, shape, or form with the bad behavior portion resolution conversation we're having here. We also talked about this situation with Maryland and how Trump is appealing the case to the Fourth Circuit Court of Appeals in Maryland. And that lawsuit was all about the fired probationary workers. Where the heck did it go? There it is. The fired probationary workers who were ordered to be rehired because Trump doesn't run the executive branch for now. The judges do in many ways. So we'll see what the Fourth Circuit says. And these cases, right, these circuits are now going to be informed by the Supreme Court decision. So this is going to be very interesting to see what happens with these other stays. So I'm excited about the developments. I think it's a great way to round out the week, my friends. And now it's time to hear from you. And let's see what you have to say about all of this and more. And once again, thanks for being here, my friends. Thanks for joining us. Members, we'll be back tomorrow for the Saturday members only stream. And we hope you join us. We're going to start sharing some of those research files around and digging into those. We're looking forward to doing that. Let's see who's here today, my friends. Thank you for sending in these super chats. Thank you for the nice donos. Thanks for being here. Thanks for joining us as we close out the week. It's been a beautiful week. Hey, what's up? It's that Friday feeling, baby. No doubt about it. And I think that's Trump with Aiden Ross, right? That's when he went over there and gifted him the Cybertruck. That was wild. What's going on? Thank you, Donut. Hey, Seymour, yo. Yo, Seymour. Thanks for becoming a member. We'll see you tomorrow on the Membos Only morning stream. And new membos, grab the stream from this morning. We had some good stuff. We've been having some good tariff talks on the stream this morning. And yesterday. Hey, this old guy says, Joe Biden probably never even knew who he was appointing. I guess this judge is an auto pen appointment. Yeah, there's a lot of them. It's just weird. I don't know why Joe Biden couldn't find any smart Americans who were born in America to be judges. They have to go. He got like tons of foreigners from everywhere. I think 3 out of his 5 DC appointments were foreigners. And then this guy was a foreigner. And it's just interesting. I just don't know. It's like apparently there's nobody born in Wisconsin who could be a judge in Wisconsin. Or no, there's nobody born in Massachusetts who could be a federal judge in Massachusetts. They had to go import him from South Korea, you know. Anyways, I'm sure that's, there's a reason for that. Hey, this old guy, what's up? Knox Bierman says, TGIF all, TRO just means that a temporary restraint. There is no proactive part of the restraint. I can request that the city be enjoined from cutting down my tree. I cannot ask the court to make them plant more trees for me. Well, maybe you should hire Mark Elias, Knox, and Norm Eisen. And they'll get you in front of the right judge who'll make them plant some more trees for you. You can get an injunction for whatever trees you want. It's your constitutional right to have trees. Don't let that dictator Trump tell you can't have trees. Hire Norm Eisen. Sheila the Pooh. What's up, Sheila? Thank you for bringing in 10 new Membo friends. Very generous and nice of you today. Sheila, bringing in Share Bear, 79. We got Bob White is here. Sergey, what's up? Stanley Start, Anything Goes is in the house. What's up, Julius VC? Welcome. And Lauren Wimberly, many shout outs to Sheila Pooh, saying Sheila Pooh rocks on Friday. No doubt about it. Hey, what's up? Angela Cranford got a gift. Eben Terblanche, David Murnane, and Three Finger Clay. Three Finger Clay in the house. What is that? I don't know. Knox says, it is hilarious that all these nice market attorneys end up with judicial appointments. Knox, it's crazy. One would think that a skilled attorney with a varied practice would make a better judge, but what the heck do I know? I'm just an attorney who has practiced 20 years. Yeah, well, you should have just donated $700,000 to Democrats, and maybe you could be a federal judge too, Knox. If only you were a corrupt piece of crap too. Knox, hey, it is off that these niche market lawyers are appointed to the federal bench. Yeah, I would think that yeah. There you go. Yeah. So basically the same comment, Knox. I think probably had to submit that twice, but it's a great comment and it is interesting. And so I've been doing this, right? I've been creating these research cards at the lodge. So these research cards, which I think are going to be a lot of fun for us to continue to reference on the show and consolidate our knowledge. So here's basically what they're looking like over at the lodge. So all these are research cards. And if we open up these research cards, we can accumulate our knowledge in a compendium like this one, like Judge Millett from the Court of Appeals in the DC Circuit, and can create these really nice dossiers on who they are and just know everything there is to know about them. And keep tabs on these folks, right? We're watching the watchers, and we're going to keep tabs on these. I really wish I'd been doing this since I started the show because we'd have some amazing files. But all right, now we know. So that's what we're working on. But as I'm going through this, my point was, Knox, as I'm going through this and like reading about these backgrounds on all these judges, I'm like, they have no experience at all. It's like, sheesh, I could go be a federal judge. Maybe I will. I'll injunction the whole government. They better watch out. What's up? Knox, I want to see these threatened pupusas. Yeah. Do you think they look scared? You think they're frightened and afraid? Good to see you, Knox. Hey, what's up? Off-Label Podcast says, hey, off topic, but Raskin admitted in a hearing the lawfare against Mayor Adams is because he chose to play along with the Trump administration about illegals. Raskin said that? Yeah, well, Raskin's another one. Mayor Adams is like, I think he's running as an independent now. And didn't he recommend Kash Patel's book? It's funny. It's funny how that works, right? As soon as you get a little taste of that Democrat justice, you're like, those people are freaking nuts. Okay. Nope, not doing anything with them again. You get one little smidge of like Democrat love of America, which is the Justice Department visiting you with the FBI. And all of a sudden you see what they're really like. He's like, I'm never going back to them again. Knox. We all kind of want to see these pupusas. I'm not going to lie. Hey, smash the like button. Smash the like button, says M.A. Allen. Thank you, M.A. Allen, for being a membo and for the recommendation on that. What's up? This old guy says, okay, so the Dems went to the border in Chula Vista, California. That's not the southern border. That's a trip to California. Yeah, I think he was going to go visit the casino and then probably have some mojitos down at the beach. Blue state Dems are comfortable. Lots of resorts available. Congress got a party, you know. I hope they had a terrific trip. Next time, try Eagle Pass, Texas. Yeah, if they want to see a border. They don't really want to see the border. That's one of the benefits of Congress. We're here for an oversight meeting. Oversight of what? This plate of ribs, baby. Hey, Sheila Poo says, it's crazy that the judge is saying the government can't verify the amount he is ordering to be paid is correct. It's crazy. It's crazy. It's like we're Your Honor, we're literally reviewing these one at a time in total compliance with the law. He's like, well, it's too slow, so it's basically in effect a pause. So you can't check anymore. So just pay out the fraudulent money. It's crazy. What's up, Deplorable One? I think the lawyer should force these judges to go on the record and state that the nominated and confirmed cabinet secretaries don't have the authority to manage their departments. Well, that's kind of what they're trying to get them to do. Honestly, that's like they're trying to get them to say that. And many of them are. And the Supreme Court just, came back down and didn't really touch on that issue per se, but did say that the courts are stepping outside of their bounds. And that's the thing, right? If the courts are shoved back into their Venn diagram, then Trump has his Venn diagram back. We need Roberts to push them back into their side. One old guy is here, says, so by his own words, Judge McConnell needs to rule in favor of President Trump because he has to look at the administration where it stands constitutionally. This judge is a foolish donkey. That is true. Yeah, it is true. He's a Democrat. Donates to Democrats, on board for Democratic ops and more. Another kid is here. Thank you, another kid, for being a membo. We appreciate that. Says, there's been a lot of these House resolutions to get rid of these political judges. When will Congress finally do something about the politicization of the judiciary? When will they even vote? Yeah, it's a good question. And like on this resolution, I don't think I have. I don't know where this resolution is in the process. I think there has been some activity on it, but I don't know where it's at. So in terms of voting and whatnot, I'm not sure when they'll vote on it, but you can track the bills and see where it's at in committee and all the things. But yeah, it's a good question. I don't think we should expect it anytime soon, which is really what you were getting at. So, but I do think that the pressure, the discussion about it, the political pressure, right? These are judges too. Like the judges are people. They pretend like they're apolitical, but they're not. They're seeing this. And hopefully John Roberts continues to get the hint. Sheila Poo says, I don't trust Mike Johnson. Yeah, a lot of people don't. I think Mike Johnson so far has been a pretty good team player so far. But you know how it goes with these Congress people, man. They're your friend until they're not. So it's something to keep an eye on, Sheila. Jeffrey Adams says, Rob, there are no blue judges. Just ask Justice Roberts. Oh, yeah. Sorry, I forgot. John Roberts said we can't have any opinions on the judiciary anymore until it's gone through the appellate process. Sorry, I forgot. Thank you, John Roberts. Hey, what's up? I drank liquor from da liquor stow. Welcome as a supporter. I drank liquor from da liquor stow. Just joined us as a member. Welcome. Fred Pedamonte says, hey, Knox, I'll come down and plant whatever you want. Whatever you want, Knox. Anything. Deplorable One says, they say Trump is terrifying. I think he's more terrifying. Hey! They say Trump is terrifying, but I say Trump is terrifying. Love it. Trump 2028, baby. Amazing. Rob says, we need to make sure that they don't create private companies that the government contracts with to do jobs to replace some of the functions, and we get more Facebook's, YouTube, Twitter et al. Hacks. From Rob on Rumble. Hey, what's going on? One old guy's opinion says, that $700K donation from McConnell bought is an appointment seat to the bench. Yes. Yeah, that's exactly right. That's right. Hey, what's up? C. John says, let it rain membos. Let it rain membos. We love our membos. Good to see you, C. John. Welcome aboard. Hey, C. John just brought in 50 membos. Let's welcome them. Lauren Larson is here. Call me legend. We got Ritz is here. Tony Leitner. Captain Sum Ting Wong. We got Urara Toast. What's up, AJ Black? We got Cerrone Almighty Bonbon is here. A little loony. What's up, D? Sean Steen. Hercules. We got Relcond. Scott Bolton. What's up, Teresa Ottaviani? We got Ray. I'm a Red Bar Bandit. Mama's here. David Anderson Sr. Soupy's here. Mark Henderson. Matthew Maddow. We got Angela D. Matt V. Heidi Smith. What's up? Potentially Criminal Sean is in the house. My friends, are you following Potentially Criminal Sean? He is right next door on YouTube. Hello. He's a very intelligent attorney and a handsome man. And he knows criminal law. So go check him out. Potentially Criminal Sean joined up as a membo. What's up? Charles Vance is here. Shauna Constant. What's up, Al Mac? What's up? E to the A. Andrew Ball. Brandon NY2Co. What's up, Jagger? What's up, DB Crypto? Champ Blue Gaming in the house. We got Henlock. Shane Rochester. Armac. Paul Gothard. What's up, James Cox? What's up, DeCant Ride? We got Be Happy. Zarupa. Joel Kirby. Schnauzer Patrol. Irish Zen. Evelia Bucher. And James Greenlee. Gifted membos, courtesy of C. John in the house. C. John, thank you for doing that. Says, let it rain membos. 50 new membos, courtesy of C. John. Thank you, C. John, for doing that. New membo friends. We'll see you tomorrow. J-Man says, YouTube is dumping some serious ads on the live streams. Oh, man. Well, one way you can do that is just to sign up for YouTube Premium. I mean, that's like one of the most valuable subscriptions I have because I don't like the ads either. But J-Man, thanks for watching them and supporting our show. Hey, what's going on? We got some other membos here. What's up? Thunderbird says, make a law for both elite and poor citizens can see justice, then all else falls into place. Yeah, I really think that if we got to see more of these hearings, if we got to tune into these hearings with these judges, people would be disgusted by what they're seeing. One old guy says, resolutions like that get many votes to the table, so they are on the table. Maybe you're talking about the impeachment resolution there, one old guy. My friends, what a bunch of nice comments and donos. Really, thank you for sending these in. Thank you for supporting us. We're excited to see our new membos tomorrow on the members only morning stream on Saturday. We also want to say hello to our friends on X who happen to be watching over there. Let's say hello and see who's joining us. X is giving me pop-ups right now. The heck was that? Hey, what's going on? Mini Tika. Fred is here. James. Jody. We got Get on the Bus. Mike Honcho. Wow. Says, here's a rumor. Pam Bondi investigating Soros. That'd be good. Robert, wouldn't this make a great RICO case to investigate Soros? Whew, yeah, it would. RICO case of the ages. Hey, what's up? Get on Bus says, Lawfare still alive. Eric Erickson says, we need an outline of illegal aliens' rights, and I don't think they should be many at all, including that to a trial hearing. They should be a human decency and treatment during detention and deportation. That's it. No torture, but no cookie either. I think you're right about that, Eric Erickson. Like, we're not monsters. We're not going to, start throwing people out of airplanes or something. We're not going to be cruel and unusual. But you don't get to break into the country. Like, here's my concern. What is the due process to the country when they come in? Like, why can they come in with all of these handouts and asylum claims and you can't deport me here and here and here and here, all on our humanity, with like no due process rights for us at all? They just come in and somebody just reviews their background, checks a couple boxes, and boom, they're asylees or something like that was Joe Biden's policy. Very fast. So why is our due process on the way out suddenly have to be so much more robust on the way out for people who are non-citizens? If you're a citizen, that's a different story, but they're non-citizens. I don't think it should be. And it's now not, according to Trump. What's up, Jody? Rob, it's crazy how the government is the largest employer in the country, produces absolutely no products. Yeah, I don't really know what the government has created for us for all of our taxes. I think it's all just been a grift and fake. Most of it. Like, what have they delivered for us? Like Obamacare? Afghanistan? Ukraine? A secure border? No. Did they help us during COVID? No. Is our dollar sound No. Do we have like amazing products and great innovations funded by all this government research to academia? No. Everything gets more expensive. The dollar is worth less every year. It's been a disaster, and a bunch of people are getting very rich off of it, but it's not America. What's up, Fred? Biden judgeship nominees confirmed by the Senate was 235. 45 judges for U.S. Courts of Appeals, 187 for district court judges, and 2 judges for the United States. Yeah, the Democrats took over the judiciary, and the Republicans were asleep. James Pepper says, Mark Carney of Canada says that Canada should replace the U.S. as leader of the free world. Okay, good luck to him. Hey, Truth Ninja. Yeah, sounds like the guy has a civil case maybe, but returned? Yeah, we don't do that from Truth Ninja. And Mini Tika sharing our Rumble link. Thank you, Mini Tika, for doing that and saying what's up on Rumble. Hey, S. Quinn. C. Quinn in the house says TGIF. No doubt about that. What's up? Says, hey, watching the Dem meltdowns every day is exhausting, but it's so much fun. Winning bigly, US. Thank you, Rob. Thank you, S. Quinn in the house. Thank you for being a very nice dono. Thanks for being a membo there. Thanks for watching on Rumble. Shout out to our Rumble friends. We are winning bigly. Like, we got the football for the next 3.8 years. And the Democrats are scrambling trying to stop it. But you can see, it's successful because of how loud they are screaming and screeching. And so, my friends, thank you so much for sending those in. I really appreciate your support today and you joining us on the week. Had a ton of fun. We covered some seriously good ground this week. But we will pause here for the weekend. Members, we'll see you tomorrow on the Saturday stream, 12 noon Eastern. Would love to see you. Can join us on Locals, can join us on YouTube as a membo, and we'll see you back here. Before we round it out, we want to thank our amazing mods and meme smiths who mod the fort down for us and keep things nice and orderly. Donut Mind Me, we got Carrie B, Playing Hooky, Dog Digger, Janek, and of course, K-Bean, modding the fort down for us, keeping things nice and orderly. We got Geegum Geegum, Just Rhonda, and Elliot also helping out. One old guy dropped this one in. Says, illegal aliens get Miranda rights for any criminal or administrative proceeding regarding the INA and U.S. Code. Under administrative returns, deportations, the highest DHS and CBP or USB administrator can order returns. Well, and so like if they commit a crime, then you would expect more process there because they're going to be housed theoretically in your detention facilities and they're charged with a violation of that statute. But like even just for simple deportation, it's like you got to see a judge and do all these things. Like, wait, why? You just let them in with a stamp. So we'll give them the same process, the same analysis. You can go back out. And if they want to apply for asylum or any of those other things, they can do it from their home country when they're not here on an illegal status. G-Man says, proof that liberals can cry for 24 hours straight and still no one cares. Yeah, it's true. And nobody even knows what he was crying about. He was just crying. It's just like, it's a typical Democrat. It's very symbolic of everything Democrats stand for. What are you screaming about? Democracy. Okay, whatever. Adam, what's up? Adam M, 17 months as a member, says, how come pardons aren't subject to the same as EOs? Maybe you're asking, like, why can't we sue to stop a pardon or something? It's not a bad question, right? Like, if they can sue to injunction Trump's EOs, why can't you sue to injunction a presidential pardon, like what Joe Biden did? I think the answer is because they're different concepts, and the pardon power has been considered to be plenary, very, very powerful and massive, basically beyond reproach. And I'm not sure that you could make maybe a TRO argument for a pardon. Like you have to rescind the pardon because Hunter's going to snort so much crack, he's going to wreck America, you know? So, wow, yeah, he is. He's snorting so much crack in his nose that California is going to fall off. So we have an injunction against Hunter's crackhead, you know, something like that. I think that's really the reason. A little bit of a different mechanism. But, my friends, thanks once again for being here on this amazing Friday. I hope your week was outstanding. I hope you're feeling ready for the weekend to unplug and to restore, to rest, to relax, to rejuvenate your spirit, whatever it is you're doing. I hope it's fun. I hope you're getting outside, spending time with your family, friends, the people that you love, and that you come back on Monday to get into it with us again, because we will be back here to do it again. Ray says, love from a Canadian living in Australia, honk honk. Thank you, Ray K. 38 months as a membo, living in Australia, honk honk. We appreciate you, Ray, for being here. And my friends, we hope that you come on back on Monday to get into it again, because we are going to be here. And in order to do it appropriately, we're going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful weekend, my friends. Sleep very well. I'll see you right back here on Monday. Bye-bye.